questions.
You argue that this law prevents access to about 97% of public areas. How do you arrive at that?
We're not arguing this specific law is banning 97%, Your Honor. The overall package of laws passed by Act 52 bans, presumptively bans, carry on 96.4%. And we arrived at that figure by having an architecture firm go through the public records of the County of Maui to determine which areas were regulated by this package of laws, Your Honor.
So that 94, I think it was 94, 97%.
96.4, Your Honor. Justice.
That includes all the areas the law bans, correct?
Yes, Justice.
I understood that much of Hawaii is state parks and state property, correct?
A portion of it, yes, Justice.
Pretty sizable portion. So that 94 is over-inclusive of private property, correct?
It includes parks and beaches, yes,
right.
Justice.
Now, and there are other areas, sensitive government areas, et cetera, correct?
That is correct, Justice.
All right. So you say that there is a constitutional right to carry a gun on private property?
Yes, Justice.
I've never seen that right. I mean, I understand that there is a right to carry a gun on private property with an owner's consent, express or implicit, correct?
The Second Amendment.
My question is very simple. Is there a constitutional right to enter private property with a gun without an owner's express or implicit consent? The answer has to be simply no. You can't enter an owner's property without their consent, correct? Express or implicit?
Correct, because that would be a trespass, Your Honor.
All right. So if we start from there, then I start from the simple proposition. You want to say that there's a custom that permits you to go on private property without the owner's express consent, correct?
Yes, Your Honor.
All right. So Justice Scalia said that every statesman at the founding knew that you could not enter private property without permission. It's a trespass, correct?
It is. You're not allowed to come onto private property that where you don't have permission to go to.
All right. So if we're looking at a custom, I thought under McKee, Justice Holmes looked for evidence, quote, that a practice had prevailed in Missouri where the suit originated. Whether you could collect shells in Missouri depended on whether there was a custom in that jurisdiction, correct?
The custom of the nation is what McKee holds, Your Honor.
And it didn't. It looked at the custom of Missouri where the suit originated.
McKee specifically talks about the laws of a nation as being what's dispositive.
McKee, Justice Scalia did in Hardeen's, but McKee, Justice Holmes, wasn't talking about the tradition of the nation. He was looking at whether the tradition of Missouri permitted people to go onto land to collect seashells.
I have to disagree. The words nation appears in that. It looks at.
All right. Well, I'll look at it more closely. But at the time of the founding, or about the time, 71, 1721, 1722, up until the founding, there were at least 3 states who prohibited hunting, as you called it, or trespassing on private property with a gun, correct? So there was not a uniform national practice.
There was, Your Honor, of carrying on private property that's open to the public. Every case that every law that you're citing to deals with prohibitions on enclosed lands. And enclosed lands, there was those laws deal with, the enclosed lands were closed to the public.
Not necessarily. Look at Mount Vernon, where George Washington lived. There was a county shop there.
By definition, if
That's a closed land.
in closed lands, I'd reference the amicus brief of the United States. They reference a law review article by Sigmund, and it goes into express detail that enclosed lands were closed to the public.
Council